Good evening, ladies and gentlemen. A very warm welcome to all of you this evening. We have in our conversation series jointly organized by IIC and PCI, Press Club of India. We have the sixth in the series. We started off with Ashish Da, then we had Ashok Vajpayee, Jagdeep Chokar, and a couple of other people who came. Alternately, we organize it in Press Club of India and IIC. So this month it was turn of IIC. So we have a very distinguished speaker today, Justice Madan Lokur, who had an extraordinary innings in the Supreme Court as judge for 6.5 years, from 4th June 2012 to 30th December 2018. And before that, previously he had been Chief Justice of Andhra Pradesh High Court, Chief Justice of Guwahati High Court, and Acting Chief Justice of Delhi High Court. He became Judge of Delhi High Court in 1999 to 2010. He was there. He has authored nearly 160 judgments in the Apex Court, and known for his presiding matters of social justice. In fact, his bench was known as the Social Justice Bench in Supreme Court. Several landmark judgments have been authored by him on various constitutional issues. And as Andhra Pradesh High Court Chief Justice, he had suspended the CBI prosecution, CBI Special Judge for granting bail to the a person who was involved in illegal mining. Before he could grant bail. Yeah. Sorry, sir. I stand corrected. And very kind person. And when I was legal reporter in Hindu, Justice Lokur was practicing in High Court. He was standing counsel also. And I always used to refer to him as a poet. He looks more like a poet rather than a jurist and a judge. So, and I went beyond, just protecting the citizenry to rest for the citizens, a healthy environment, be it in securing elephant corridors in Kunur, clean air in National Capital Region, lakes and forests across the country. And we all know he's known for his liberal values, taking the government to task and at times very hard on the sluggish bureaucracy. And if you see the recent headlines in media where Justice Lokur has spoken his mind about various issues, so the headlines come across as if government comes in total control of judges' appointment, we'll be heading for disaster. Center note, entitled to segregate Collegium resolutions, Supreme Court should act tough against executive for sitting over proposals. So we are very fortunate to have him today, and to moderate the discussion, we have Suhas Borker. Suhas Borker has been moderating this discussion right from the beginning. Suhas is a senior journalist who has traveled with many personalities abroad, and he is also involved in a lot of civil society work. He heads the Citizens First Television, and further than that, I think Suhas is a well-known figure, but as in IIC and in our discussion series also, in Press Club also, and in IIC also. And before we begin, Suhas, to continue with the tradition, I'll request Swati Mathur, our Joint Secretary of Press Club of India, to present a memento as a token of appreciation to Justice Lokur.
Pre-appreciation.
Thank you very much.
Over to Suhas.
I can take the liberty to address Justice Madan Lokur as Madan. We've been right from kids at school together and then in college together. So thank you, Madan, for joining us today. Now, today happens to be Martin Luther King's, at least in IIC, we commemorate his birthday today. And there were students in the morning, and we had this famous saying from Martin Luther King, injustice anywhere is a threat to justice everywhere. Now, this is his letter from Birmingham jail on the 16th of April, 1963. Now, taking a cue from that, and then also we'll, after this, we'd request you to just go down into the Gandhi King Plaza and light a candle for justice. We've arranged candles there, so just light a candle to King and Gandhi, and of course the mission Madan has taken up on his shoulders. So Madan, of course, will be talking on the challenges, and he'll be touching the salient challenges, what he feels. But of course, uppermost on our minds are the attack on the basic structure of the Constitution and the Collegium. Now, without further ado, I'll request Madan to take the floor.
Yeah, thank you, Vinay. Thank you, Suhas. Let me begin by saying that when I accepted the invitation to speak.
Yeah, it's okay.
Yeah, when I had accepted the invitation to speak, the controversy of
it's on.
The mic.
It's on.
The controversy about the appointment of judges, the controversy about the basic structure had not erupted, if I can use that word. So really my presentation is a little more mundane. We can discuss that later, of course. But for the present, it's going to be a little mundane sort of a presentation on the challenges that are facing the judiciary and also the possible solutions that can be found. You see, first of all, I think in everybody's mind is the fact that there are a very large number of cases that are pending. As far as I'm concerned, I think it's just gone beyond control. Every day, if you look at the website of the e-courts platform, you'll find that there's an increase in cases. And the figures that I saw yesterday were that in the high courts across the country, there are 5.98 million cases that are pending. In the district courts across the country, there are 43.26 million cases. In other words, 49.24 million cases, that is about 5 crore cases are pending across the country. And the number is increasing on a daily basis. I've given you figures of yesterday. Today, just before coming over here, I checked the figures. Again, it's gone up by something like 20,000 or 25,000. So the enormity of the number of cases is one massive challenge. Along with that is the challenge of the number of years that cases have been pending. In the high courts across the country, cases that are pending for 20 years and more, all right, is about 2.95 lakh. And in the district courts, the cases that are pending for 20 years or more is 6.75 lakh. So that's a huge figure, almost about little more than 9 lakh cases that are pending for more than 20 years. Now, under the memorandum of procedure that has been prepared by the Supreme Court and which has been sent to the government is a little ambivalent whether they've accepted the memorandum of procedure or not. Judges in the High Court are appointed at the age of 45 and above. So when we are talking about cases that are pending for 20 years and more, okay, judges at the Supreme Court level retire at the age of 65. So the life of a judge in the High Court and Supreme Court is 20 years. So when we are talking about these cases pending for 20 years or more, we are talking about the next generation of judges. So I think the figure it looks to me to be quite unmanageable unless some drastic steps are taken. Now, the Supreme Court figures are considerably less, obviously, but the figures in the Supreme Court are also going up. From the material that is available on the Supreme Court website, found that 1st of March 2018, the number of cases pending in the Supreme Court was 55,529. 1st of January this year, the number has gone up to 69,768. So in a matter of 5 years, it has gone up by about 14,000, which means roughly 3,000 per year is the increase of cases pending in the Supreme Court. Now that's a phenomenal increase. There are jurisdictions where you don't have so many cases being filed, but here we are adding to the numbers. So really, whether you look at the problem from the point of view of the district courts, which is the first point of contact that any citizen has with the justice delivery system, or the high courts or the Supreme Court, you are looking at a huge pendency of cases. One of the reasons, and this is also a challenge, is the number of vacancies that are in the courts. Now, the Department of Justice maintains the figures so far as the high courts are concerned, and from the website of the Department of Justice, I discovered that on the 3rd of January 2023, 1st and 2nd being holidays, the number of vacancies in the high courts across the country is 339 out of a total sanctioned strength of 1,108, which means that the vacancy position in the high courts is 30%. In the district courts, it's a bit of a longish process because you have to go through each high court website. But on an earlier occasion, when I had done this exercise, the figure came to about 20%. I don't think it has gone down substantially, nor has it increased substantially. So when we are talking about 20% vacancies in the district courts, you are talking about 1/5 of the number of judges. The sanction strength is little over 20,000, so you're talking about 4,000 vacancies. In the high courts, you're talking about 30%, which is 1/3, 339. So these are really the two so-called traditional challenges facing the courts. That is a very large number of cases, number one. Number two, the large number of vacancies. There is a third very serious challenge that is facing the courts, the justice delivery system, and that is the absence of adequate infrastructure. You may remember that when Chief Justice of India, Justice Ramanna, before he became the Chief Justice and after his name was recommended for appointment as Chief Justice, he spoke about having a Judicial Infrastructure Commission, which is to say that the judicial infrastructure would be taken over by some commission. The details had not been spelt out. He was the Chief Justice of India for more than a year, and towards the end of his tenure, the government said, we are not accepting your idea of a Judicial Infrastructure Commission. So that was that. I mean, nothing happened for 1 year. That is one thing. The second thing is that even if something happened, it was negative, where they said that, we're not going to do anything about it. Why is this a problem? In the Allahabad High Court, I'm just giving a few examples. In the Allahabad High Court, the number of judges who have to be appointed is about 150 or so. They don't have chambers for so many judges. They don't have courtrooms for so many judges. So even if the vacancies are filled up in the Allahabad High Court, where are the judges going to sit? There's no court for them. There's no chamber for them. Nagpur. I have been to the district court in Nagpur a couple of years ago, and there was a biggish sort of a hall. I mean, not this kind of a shape, but a rectangular shaped hall, about this size. There was a curtain in one portion of it, half of it, and there were these Godrej almaras in the other half. On this side, there was one judge holding court, and on this side, there was another judge holding court. Now, if the lawyer is arguing in this court, you can hear it in this court. And if he's arguing in this court, you can hear it in this court. So, in other words, a hall was divided into two courtrooms. That is the kind of infrastructure that is given in a place like Nagpur, which is, not a small town. Nagaland, I have been to Nagaland when I was Chief Justice of Guwahati. Pathetic conditions. The judge did not have electricity in his courtroom. So what he had done was, the public prosecutor had electricity. So he took a connection from the public prosecutor's room and, put a bulb in his room. That's the kind of condition it was there. Now, if it rains, the electricity goes off. Okay, so they can't work. These are, examples that I have myself experienced. I had gone to Chittoor when I was a Chief Justice in Andhra, and I met one lady, judge, and she was saying, I have a bit of a problem in my court. So I said, what is the problem? She said, when it rains over here, the roof leaks, right? And it leaks right above my head. So I can't sit in the courtroom. Okay, so for about a month and a half or 2 months when it rains, she can't hold court. Okay. So these are the kind of infrastructure problems that are existing. Work has been done by organizations. I remember going through an article in firstpost.com. That was an article of 2018. They said, now this is interesting. They said that in 2015, the Department of Justice had recorded that there were 16,513 courtrooms in the district courts for 16,070 judicial officers. So there were enough courtrooms for the judicial officers. But in 2010, the Supreme Court Center for Research and Planning, this is within the Supreme Court, sorry, in 2016, not 2010, in 2016, a year later, the Supreme Court Center said that there are now 15,540 courtrooms. So the figure came down from 16,513 to 15,540. Okay, could be a mistake, fine, we can grant them that benefit of doubt. But these 15,540 courtrooms were for 20,553 judges. In other words, 5,000 judges had no courtroom. Now, what do you expect? Obviously, the number of pending cases are going to go up. Obviously, you're going to have a lot of persons who are not going to get justice. Why? Because the judge doesn't have a place to sit. Where is this case going to be heard? This is the kind of problem. What about the conditions of the judges? Again, according to the Supreme Court Center, 8,800 residential units. We are short by 8,800 residential units, which means that out of 20,000 judicial officers, only 12,000 of them have got houses. 8,000 don't. So you take it on rent, you're at the mercy of the landlord or whatever the arrangement is. This is the kind of condition in which our judges are working, and which I'm afraid is not being addressed by the government and whoever is supposed to be concerned with this. Why is it not being addressed? These are figures I'm now going to place before you, which were placed before the National Judicial Academy in Bhopal last week when I was there. The expenditure on the judiciary of the GDP is 0.01%. That's the expenditure on the judiciary, and judiciary, remember, is one of the pillars of democracy. 0.01%. the center spends 0.08% of the budgetary expenditure on the judiciary. So the judiciary is financially neglected. That's why you have problems of no courtrooms, no houses. This results in pendency. This results in vacancies. So the whole thing, is in a complete mess, so to speak. These are the kind of problems that we have. And now there have been studies. Toilets are missing out of, I think, about 500 court buildings that were surveyed. There are no toilets for ladies in about 100 of these buildings. In others, also, it's the same position. In Guwahati, we had organized a program, and before the program started, there was a, sort of a tea session, and everybody came and met one particular judge. Very respectfully, they spoke to him, district judge. So I asked one of my colleagues, I said, what is the importance of this person? I mean, everybody's coming and, paying their respects to him. So he said, I don't know. Then same thing happened in the lunch break. So I asked one of the judicial officers, I said, what is so special about this judge? That judicial officer said that there's a particular place, I don't remember the name of that place, where in the court building, it's a large court building, there's not a single toilet, right? Either for ladies or for men, there's not a single toilet. This person's house was about 100 yards away from the court building. So everybody used to go to his house, and that's why he was so popular, because they were all thanking him for this. I mean, these are, the kind of conditions in which our judges are working. And we need to give it some serious thought, So, yeah, this is what, I would like to say about the challenges that we are facing. Now, to this you can add, the controversy about the appointments and so on and so forth. What about the solutions? Because fine, we can go on talking about challenges. We've been speaking about them for the last so many years. Nothing has been done about it. But there are some solutions. One of them is, of course, releasing more funds, doing something about infrastructure. These are obvious. But we have several resources at our command, which I'm afraid are not being utilized by the judiciary and, of course, with the assistance of the government. One of them is Lok Adalats. They are extremely popular. The 13th Finance Commission had made a huge allocation of funds for the Lok Adalats, but now Lok Adalats have become some sort of a festival. 5 lakh cases decided in the Lok Adalat, 2 lakh cases decided here, National Lok Adalat, front page of the newspapers and all that. It's okay, you can give it publicity, no problem with that. But that is where the common person goes. For a Lok Adalat, a common person cannot wait for 10 years, 20 years for his case to be decided. Today, there is an item in the newspapers, in the Telegraph, about a professor from Jadavpur University. Forwarded, he was not the originator, but he had forwarded a cartoon, I think, lampooning the Chief Minister of West Bengal. In 2012, he was arrested. A case was filed against him under the IPC, Indian Penal Code, and also under 66A of the Information Technology Act. The court said, and the police also agreed, that there is no case against him under the IPC. The Supreme Court struck down Section 66A of the Information Technology Act in 2015. But the case continued against him. Why? Because the police said, we want to revive the IPC provisions. What were the IPC provisions? One was defamation, all right, for forwarding a cartoon. The other one was lowering the dignity of a woman. Yesterday or day before yesterday, the cases against him were closed. So 11 years, he was just going through this. He gave a statement that he had 72 court hearings. Okay, so forget about teaching in the university. All he was doing was going up and down to the courts. He had a passport. He had to renew that every year. They said, we can't permit you to go abroad, supposing you abscond. So, again, now, you know, these are challenges that people face, ordinary people face. The girl from who was accused of sedition and arrested in Delhi, she was brought from Bangalore. She wanted to go for this, COP 26 or COP 25 in Glasgow. She was not given a passport. She's an environmental activist. She was not given a passport. Why? Because there's a case of sedition pending against you. So, you know, these are, you know, collateral damage, if I may say so, that happens because of dependency of cases. So, Lok Adalats, I think, is one solution which we should look at, but we do not, except as a festival. We have permanent Lok Adalats of utilities. You have electricity companies, right? You would have insurance companies. They have permanent Lok Adalats, or at least they're supposed to establish permanent Lok Adalats so that, you know, common people don't have to go to the court. They can get their solution over there. And from persons like you and me, you know, any one of us can become a member of a Lok Adalat, but nothing is being done about it. Free legal aid and advice. Again, it's there, but not being utilized. I can tell you, when I was the chairperson of the Supreme Court Legal Services Committee, I carried out an exercise, a performance to see how we are performing. And you'll be surprised. I got some people from the National Law University in Delhi, some professors to conduct this performance audit. To my horror, I found that cases had not been filed by poor people who had approached the Supreme Court Legal Services Committee for filing an appeal in the Supreme Court. Cases had not 12 years, 13 years. Some of them were by persons who were undergoing a life sentence. And life sentence would ordinarily mean release after 14 years. So for 13 years or 12 years, their case was not filed in the Supreme Court. We asked the people, there were something like 700, 800 files that were live. We asked 700, 800 people. I told the lawyers, I said, please ring them up one by one. About 50% of them said, listen, we don't want your services. Why? Because either our sentence is over, or we have taken a private lawyer, or we are not interested. That is the condition in which the Supreme Court Legal Services Committee was working. And if that is what is the position in the Supreme Court, you can imagine what it would be in the states, what it would be in the districts, what it would be in the taluka. Again, a solution that is available to us, not being utilized. For the person, the individual, the common person in India is the one whose focus is what I have in mind. We have amendments made to the Civil Procedure Code. Arbitration was encouraged. There has been always an Arbitration Act for a long, long time. But the Civil Procedure Code was
Put it in the center, yeah.
Yeah, would you like me to come here? I can come here. Huh?
That menu, please.
Yeah, sorry. Yeah, thank you. Okay, so arbitration is one of the solutions which is there in the introduced by an amendment to the Civil Procedure Code, not being taken seriously. There are attempts, about improving the arbitration culture, but nothing has happened over the last so many years. Mediation is again something which was introduced. It was very, very successful in the district courts in Delhi. More than, I think, 2 lakh cases were resolved. The Delhi High Court has a very vibrant mediation center. Madras High Court has a vibrant mediation center. It didn't work very well in Bombay High Court. It's working very well in Karnataka, in Bangalore. But again, a solution that is available to us and no cost. The mediators are prepared to work free, but we are not taking advantage of it. A mediation bill is supposed to have been passed long time back. I don't know what has happened to it. What are the contents of that bill? They don't take the ground reality into consideration. So it's okay, one day some legislation will be passed, but what will be the efficacy of that legislation, one doesn't know. Plea bargaining, criminal cases. In the United States, about 95 or 97% of the cases do not go to trial, criminal cases. They do not go to trial. Why? Because there is plea bargaining. So a person is accused of something, his lawyer and the prosecution will discuss. He will say, all right, I plead guilty, give me a lesser punishment, or make it into a lesser offense. And fine, the purpose is served. We have introduced plea bargaining through an amendment in the Criminal Procedure Code. I think it was way back in 2007 or 5 or something. Nothing, absolutely nothing has been done about it. We experimented with plea bargaining in the district courts. It worked, but then after about a year or so, it was given up. What I'm trying to say is that we have the tools. We have to make use of these tools if we want to go anywhere. Can you imagine if 95% of our criminal cases are taken off the docket? What will be the pendency? It will be hardly anything. But we are not making that effort. What about mediation? Again in the United States, most cases are resolved through mediation. But we are not doing anything about it. We have tribunals and commissions for consumers, consumer commission. We have administrative tribunals for disputes on service matters. Again, vacancies by the dozen. You have under the RTI, you have this information commissioner. 20,000 appeals are pending. Why are we not looking at these things? Justice delivery is not only in the courts. It's everywhere. It's in these commissions, it's in these tribunals. And as Suhas was quoting Martin Luther King, injustice anywhere is injustice everywhere. So you have injustice even in these tribunals, you have injustice even in these commissions. What are we doing about it? We have introduced something called virtual courts under the e-courts program. This was in 2017, where for something like traffic challans, Delhi at that time was issuing something like 1,500 traffic challans every day. There were, as far as I remember, about 12 or 16 judges, magistrates, who were dealing with traffic challans. There was any amount of corruption because you had touts who were, who would say that we'll make sure that the challan disappears. Online courts, virtual courts were established, where you just go to the website, 99% of the cases, everybody pleads guilty. If you plead guilty, pay the minimum fine, whatever it is, 50 rupees, 100 rupees, 500 rupees, whatever it is, pay the minimum fine. If you want to contest, you say, I'm not guilty, fine, you can go to the court and say, I'm not guilty. Nobody, no court has picked it up. I don't know how it's functioning in Delhi at the present moment, but I remember inaugurating it in 2017 when I was the chairperson of the E-committee. It worked very well. Today, I don't even hear about it, you know. So again, you have a resource which you're not utilizing. Gram Nyayalayas, it's a law enacted by Parliament for, again, the common person. You don't have to go to the courts, you don't have to go to the capital, you just have to go to your village. There's a Gram Nyayalaya over there. Whatever dispute you have, get it resolved. Not established. And those Gram Nyayalayas which have been established, there was a report a couple of years ago, I think it was done by Vidhi, I'm not very sure. Dismal performance. Why is it that we are not utilizing all these resources so that we can overcome the challenges that are before us? Somebody has to, answer this. How many more resources do you want? Parliament has given us all these resources. Many of them are there through judicial orders. Lok Adalats were established because of judgments given by the Supreme Court. Free legal aid was given because of judgments by the Supreme Court. So it's two wings of the democracy, Parliament and the Supreme Court and the Judiciary, which have encouraged this, but we are not utilizing them today. Why? There are other, procedural solutions. This really can curtail litigation in the Supreme Court. We have articles in the Constitution of India, Article 132, Article 133, 134, which require that any judgment given by the High Court, if you want to go to the Supreme Court, you can go to the Supreme Court, get a certificate from the High Court that a substantial question of law arises, or a question of constitutional importance arises, or a question of general importance arises. Nobody, at least as far as I know in the last 20 years, except perhaps in one particular case, I don't know how that happened, but in the last 20 years, I don't know of anybody who has approached the High Court for a certificate to go to the Supreme Court. Everybody files what is called a special leave petition or an SLP under Article 136. And the Supreme Court has said that the power available to the Supreme Court to entertain petitions under Article 136 of the Constitution is an exceptional and overriding power. Today it is being used by everybody. It is not exceptional, it is not overriding, because certificate for leave to appeal to the Supreme Court has been completely forgotten. 3-4 articles of the Constitution are not being used for going to the Supreme Court. Now, if the Supreme Court insists and says that, listen, get a certificate from the High Court, first of all, the litigant doesn't have to come all the way to Delhi. There are complaints that, how can people from Guwahati come to Delhi? How can people from Cochin come to Delhi, or from Trivandrum, or from Bangalore? Miles away. You have to come here, hire a lawyer, spend on transport, spend on accommodation. But how about going to the High Court and asking for a certificate? How about finality being attached to judgments of the High Court, particularly in cases where the High Court is dealing with the local state law? Why should the Supreme Court decide, whether the Bombay Rent Act, section so-and-so, has a particular interpretation? How are people in West Bengal concerned? How are people in Tamil Nadu concerned? Only people in Maharashtra are concerned. And the Bombay High Court, when it delivers the judgment, fine, accept it. In other words, only parliamentary laws should be the subject matter of interpretation in the Supreme Court. But no, that's not happening. You have small, petty laws, filed in different states, which are coming up to the Supreme Court and clogging the system. That's where you get the 70,000 cases. There used to be at one point of time something called the Fish Act or the Fisheries Act or something in Delhi, which said that if you buy or sell fish after 7 p.m., you're committing an offense. Right? There were allegations that the cops would go to somebody and ask for free food, and if that vendor said no, say that, oh, he was selling fish, it was 8 o'clock. 300 cases were pending. A former Chief Justice of Madhya Pradesh High Court who came to the Supreme Court told me that 50,000 cases were pending in Madhya Pradesh at one point of time against forest dwellers. Why? Because they used to collect the wood that had fallen, twigs, for fire. You're taking something away from the forest. You're not allowed to take anything from the forest. So these forest dwellers had to face 50,000 cases. He spoke to the chief conservator of forests of the state, spoke to the Director General of Police and said, what's going on? And they were cooperative enough, and they said, yeah, we'll withdraw all these 50,000 cases. That's where, if there is a will to bring about this change, it can be brought about. And in one stroke, 50,000 cases were over. In that Fish Act or Fisheries Act or whatever it is, 300 cases were over. There are several other, solutions. One is, of course, to not to waste the time of the Supreme Court, have good, elaborate written submissions available. I also happen to be a judge of the Supreme Court of Fiji. The procedure over there is that lawyers can argue for a maximum of 40 minutes. Of course, if somebody wants to argue for more than 40 minutes, we permit. It's not that we are rigid about it. But out of all the cases that I've done, there are only 2 cases in which we said, okay, you can exceed that time limit. But by and large, they finish their submissions in 20 minutes, 15 minutes, 20 minutes, 25 minutes, over. Why? Because they have excellent written submissions. They've got their training, most of them have got their training either in Australia or New Zealand, which are the nearest countries. But outstanding written submissions, why can't we do that? Why is it that we have to go on arguing cases for days together, months together, when you can put down whatever you want to say in a written submission? The American Supreme Court does that. A small country like Fiji does that. Why can't India do it? Okay. Case management. Why can't we look at case management? The Supreme Court had requested a former chairman of the Law Commission, Justice M. Jagannath Rao, to consider preparing rules for case management. And Justice Jagannath Rao prepared rules not only for case management but also for mediation. They were approved by the Supreme Court in 2005. They're still there in the law books. Nobody from 2005 till today has implemented those case management rules. Nobody has implemented those mediation rules. And Justice Jagannath Rao, a former judge of the Supreme Court, former chairperson of the Law Commission, spent a couple of months preparing these rules. He did a first-class job, but that's it. Process re-engineering. That is something that is required. I mentioned to you about this professor from Jadavpur University, 72 hearings. Is there something wrong with our process? Of course there is. Why should he have to go to the court 72 times? I have come across a case which was pointed out in a regional program in Jodhpur a couple of years ago, a couple of years before COVID. 149 adjournments in one case. Is there something wrong with our process? Of course there is something wrong with our process. Are we looking at it? No, we are not looking at it. Movement of cases in the court, that's also a part of process re-engineering. It's not only what's happening in the court, but it's what's happening in the registry. Efforts have been made. We got the, what is it called, FMAS, Faculty of Management Studies, Delhi University, to conduct a study of the Supreme Court. They did it free of cost. It's just lying somewhere. A study was done in Andhra Pradesh, Hyderabad, by a very renowned institute over there. I don't remember the name just now. Nobody had a copy. Even the High Court didn't have a copy. When I came to know about it, I rang up that institute. I said, "Do you have a copy?" They said, "Yes, we have one copy. We'll give it to you. But the High Court owes us some 3 lakh rupees or something for our services, which they haven't paid." I said, "You please give that money to that institute. They've done the work. Get a copy of the report," but not implemented. So process re-engineering is something now, with the advent of technology, computerization, digitization, and so on, we need to look at these processes. So you have a third dimension. One is the processes in the courts. Second, the processes in the registry. The third, processes due to the implementation of technology. But nobody has the time, you know. Nobody has the will. And, you know, attacks are being made. Why is there so much of pendency? Why is this? Finally, judicial education. We need to concentrate on training our judges properly. You would have heard of that case where that judge was talking about, I think it was under the POCSO Act, where she came out with this theory of skin-to-skin contact. Unless there is skin-to-skin contact, there is no sexual offense. Now, if we are going to have judges with these kind of ideas, what is the kind of progress that we are going to make? The world is developing very, very fast. Legal front, you have cases in the United States on issues pertaining to artificial intelligence. We haven't even thought about it, right? You have new laws coming into force. Biodiversity Act, there's only one judgment that has been delivered by the Uttarakhand High Court. We are not concerned. Unless we train our judges, a small thing like bail, you know, I mean, that's the first thing that you learn in criminal law when you go to the law faculty or go to the law school. When to grant bail, when not to grant bail. And you've seen over the last couple of years the turmoil. Somebody gets it in one day, somebody doesn't get it. Others who get it, they have a problem in getting a surety. Why? Because the police says, "Oh, you know, we have to verify the surety." Some girls who were accused of, instigating the Delhi riots that took place, they said, "Oh, you're from Assam, so we'll have to send somebody to Assam to get to verify the surety." Kapan is still in jail because they couldn't verify the surety. Why? Is it the idea that you have to keep people in jail? What is it? You know, now how is it that the courts do not look into this and say that, listen, personal liberty is something important. Don't just say that, I have to verify the security, the surety, I have to do this, I have to do that, and all right, this person just languishes in jail. There are persons in jail who have been there, who have got bail, but they've not been able to produce the surety, or the amount is too high for a security. What do you do in a situation like that? So, judicial education, in my view, is the answer. So, we have, a whole range of problems. We have a whole range of solutions. Some of them pertain to, the systemic problems. The solutions are also systemic. We have resources which we are not utilizing. I wish we do. And we have procedural solutions which I think we should try and implement. So, yeah, that's all that I have to say. Yeah, thank you very much.
Thank you, Madan. But I think, I mean, it's a very dismal picture which you have painted. I mean, it's probably the picture which is there. So you're showing ground reality, and there is no will. But I think, please do touch on the two issues which came post your working on this presentation. One is the Collegium, and the second is the basic structure of the Constitution. Because we can't let this meeting go without your touching these two.
Okay.
Thank you.
Yeah. Now, I'll just very briefly tell you about the basic structure. There was this case, you all must have heard about it, Keshwanand Bharati's case, where there was a split decision 7-6. And what emerged from that decision, 1973, Supreme Court, is that the Constitution has a basic structure. Okay. Democracy is a part of the basic structure of the Constitution. Independence of the judiciary is a part of the basic structure of the Constitution. Freedom of speech is a basic structure of the Constitution. Now, during the emergency, after Mrs. Indira Gandhi's election was set aside by the Allahabad High Court, an amendment was passed, 39th Amendment, which said that the election of the Prime Minister and the election of the Speaker cannot be challenged, and that was with retrospective effect. Therefore, the judgment of the Allahabad High Court in that sense was, retrospectively set aside, and the challenge to that, to her election, was therefore, not a valid challenge. The Supreme Court said you can't take away our jurisdiction of judicial review because impact on justice delivery, number one. Number two, they also said that free and fair elections are a part of the basic structure of the Constitution. So, that basic structure doctrine has been applied in the anti-defection 10th schedule to the Constitution. They said that whatever is decided about defection, no court will have jurisdiction. The procedure was not followed because you have to get the consent of the state legislatures. That was not done. That was one objection. The second objection, of course, was that you are taking away the power of judicial review, which has been conferred by the Constitution and which is a part of the basic structure. So you have some, well-defined aspects, free and fair elections. You can't say that, from tomorrow onwards, elections need not be free. From tomorrow onwards, they need not be fair. Why? Because we are amending the Constitution and we are putting a section or an article in the Constitution to say that from tomorrow onwards, there's no need for any free and fair elections. That's violating the basic structure. Can that be accepted? Tomorrow, supposing they amend the Constitution and say that, India ceases to be a democracy and we're now going to have a monarchy. Can that be accepted? That's a basic structure of our Constitution, democracy. Or tomorrow if they say that, judicial review is taken out, no court will have jurisdiction to look into this. Any decision taken by the executive is final, no court can challenge it. So if somebody is dismissed from service, he is dismissed from service. You can't look into it. Judicial review is a basic feature of the Constitution. So really, these are things which are a part of the basic structure of the Constitution. And if we take away the basic structure, you are inviting a problem. Because then Parliament can do exactly what it wants. And this was argued, extensively by Mr. Palkiwala. Incidentally, 16th of January was his birthday, so all this controversy started, around the time of his birthday. But anyway, a review was taken up in the Supreme Court. And of course, I wasn't present at the review, but senior lawyers who were present when the review was being argued by Mr. Palkiwala they tell all of us that the performance that he, the arguments that he gave and his performance was superb and sterling. The result was that what happened to the review petition, nobody knows. There was no judgment given, nothing. What has happened to it, nobody knows except what is in the memory of these lawyers. That is the importance of the basic structure of the Constitution, which the Supreme Court has realized and which it has implemented. In the NJAC judgment, I happen to be a member of the bench, so I don't want to talk too much about it. But it was the independence of the judiciary. We felt that the independence of the judiciary is going to be compromised. And the independence of the judiciary is a part of the basic structure of the Constitution. It's a basic feature. You can't have a judiciary which will agree with the government every time, or which will agree with the citizen every time. The idea of a committed judiciary was, formulated when Mrs. Indira Gandhi was the Prime Minister. And she tried, 39th Amendment was part of it. It didn't work out. Why? Because everybody wants a judiciary that is independent. Can you imagine going to court knowing that this judge is going to decide against me? Why will you go to court? So that is the value of the independence of the judiciary. When you know that the judge is biased, prejudiced, going to decide against you, it's like going to a cricket match where you know that the umpire is going to make the other side win. Which team will play? You say, forget it. I mean, if he's going to decide everything, that's it. So the basic structure has to remain if we have to remain as a democracy. And some of these basic features like a free and fair election, judicial review, independence of the judiciary and all that has to remain. Otherwise we cease to be a democracy. The second thing is about the Collegium system. Now the Collegium system has been working very well, in the sense that there are controversial decisions that have been taken. There's no doubt about it. But that's bound to happen in a system of selection. One of the problems is that there is no set criteria. How do you decide that this person is a good judge and he will continue to be a good judge when he comes to the Supreme Court, or he's a good lawyer and he will continue to be and he will be a good judge when he's appointed to the High Court? This is a question which can be asked. Now, I can tell you that for the appointment of judges to the High Court, where we have 30% vacancies, there is a system of checks and balances. The Chief Justice of the High Court, along with the two senior most judges, they recommend a person for appointment as a judge of the High Court. The case papers, the file, if I may call it that, or the recommendation, is sent to the Chief Minister of the state, it is sent to the Governor of the state, it is sent to the Law Minister. The Chief Minister can point out any objection that he may have. The Governor may have an objection, he can point that out. The Law Minister through the Intelligence Bureau and this Chief Minister through the local intelligence, the Law Minister can point out any objection that he has. So with all this material, the file goes to the Supreme Court Collegium, which consists of the Chief Justice and the two senior most judges. They have everything before them. They have the views of the Chief Minister, they have the views of the Governor, they have the views of the High Court, they have the views of the Department of Justice. In addition to that, the Collegium takes the views of judges who are associated with that particular High Court. So I'm just giving it to you as an example. If a recommendation is made, to appoint somebody as a judge of the Delhi High Court, they will ask, the Chief Justice will ask who are associated with the Delhi High Court that, listen, this person is under consideration. He has been recommended by the Chief Justice of the Delhi High Court and the two senior most judges. What is your information? Is he fit to be appointed or is he not fit to be appointed? Do you have any material against him? What is your view? And depending upon the number of judges, there have been instances, I know from Madras High Court, for example, five judges who were not in the Collegium were consulted at one point of time. In Delhi High Court, today we have, I think, at least 2, maybe more judges, 3, who have some connection with the Delhi High Court. Their views are taken. So you have the High Court views, you have the Chief Minister's views, you have the Governor's views, you have the Law Ministry views, you have the views of judges of the Supreme Court. Then the Chief Justice of India and the 2 senior most judges take a view and say that yes, we think that on the material before us, this person should be appointed or this person should not be appointed. And they make that recommendation. So there are enough checks and balances. Now, in spite of that, things can go wrong, right? I will not say that it is foolproof, but you have these checks and balances. If there is a problem, well, it's a failure of the system. The issue really comes up when you're dealing with the appointment of a Chief Justice of a High Court or when you're dealing with the appointment of a judge of the Supreme Court. The Supreme Court Collegium for appointment of judges to the Supreme Court consists of 5 judges, Chief Justice and the 4 senior most. They make the recommendation. And normally, there have been exceptions, but normally they make recommendations from the High Court, either a senior judge or the Chief Justice of a High Court. Now, that senior judge or that Chief Justice has been a judge of the High Court perhaps for 10, 12, 13 years, right? You have to be a judge for that period of time because of seniority issues, not that there's a bar. Justice Krishna Iyer was a judge for, I think, about 7 years when he came to the Supreme Court. He was a minister of law in a communist government in Kerala, right? So yeah, you have these exceptions, but by and large, a judge, a person who's been a judge for about 10 or 12 years, he is under consideration. The judges have been judges, or the Chief Justice, or senior judges of the Supreme Court have been judges for almost about 20 years. So they know the not 20, maybe 15 years. So they know the person under consideration. They have read his judgments. They have met that person in all probability. They can ask their colleagues. They can ask lawyers. That has been done. Even the Chief Justice of the High Court asked lawyers. As a Chief Justice, I asked lawyers that, certain certain lawyers are under consideration for being appointed as judges of the High Court. What is your opinion? And they've given their opinion. It has happened in Delhi High Court. I have done it in Andhra. I have done it in Guwahati. The Supreme Court does it. Whether it has happened in certain cases or not, I can't say. But after this consultation process is over, the recommendation is made. Now, there have been problems. I'm not saying that there has been no problem. But you have, somebody like Justice Akhil Qureshi, who was supposed to go to the Madhya Pradesh High Court. It seems that some objection was raised by the government. Now, why should the government say that, listen, we want this person as a judge? What is their interest in it? The government is the biggest litigant in the country. Can the government be allowed to say that, listen, we want a particular person as a judge. We don't care for your opinion. You are unbiased because you're a judge. You don't have any bias. You don't have any prejudices. But we want somebody of our choice as the Chief Justice of a High Court or as a judge of the Supreme Court. First of all, I don't think that's correct. Second, even if that happens, assuming it happens, I think there should be a dialogue. Why is it that the Law Minister and the Chief Justice or the Law Minister and senior judges cannot speak? I remember when I was in the Collegium, there was some problem. I don't even remember what the problem was. And we requested the Law Minister, Mr. Ravi Shankar Prasad, at that time, that can you please, come to the Supreme Court for a cup of tea? We want to discuss something with you. And he came. And the matter was sorted out, even before that cup of tea could be over. So why is it that, speeches have to be made in public? I'm saying this, I'm saying that. Why can't they just sit down and talk? The other problem really is that of reiteration of names. Now, the Supreme Court judgment says that when we make a recommendation, when the Supreme Court makes a recommendation, unless you have a very good reason to reject it, you process it. Why? Because you've already processed it. And then send it back to us. And when we have a look at the file again, on the basis of your fresh objections that you may have had, and we don't accept those objections, please appoint that person. But what has happened in the recent past is that there has been one reiteration, there has been a second reiteration, and a file has been sent to the Supreme Court third time. There have been instances where the file is lying with the government for months together, and in some cases for more than a year, more than 2 years. One Mr. Aditya Sondhi was recommended as a judge of the Karnataka High Court. So that entire process, which I had mentioned to you, High Court, Chief Minister, Governor, Department of Justice, Supreme Court, that entire process had been gone through. For 1 year, no action was taken by the government. He said, listen, forget it, I'm doing pretty well as a lawyer. If you don't want to appoint me, don't appoint me, I'm quite happy. And he withdrew his consent. That is the danger. So now we lost a good judge. Okay? Supreme Court appointments. Justice Dipankar Datta, who's the latest person to be appointed, no decision was taken for 75 days whether he should be brought to the Supreme Court or not. Why? If there was something against him, did the government tell the Supreme Court that, listen, there's something against him? There was obviously nothing against him, but no action was taken. On the other hand, cases are processed in 2 days. There are instances last year when cases were processed in 2 days. Why? Justice K. M. Joseph, who is now a sitting judge of the Supreme Court and number 3 in seniority, his case was not processed. The result was that the cases of others were processed for appointment to the Supreme Court. They became senior to him in the Supreme Court, just because of sheer delay. And this can have an impact on a judge of the High Court. If a person, Saurabh Kripal, for example, has been in the news, his case was not processed. He's lost at least 4 years, if not 5 years of seniority. There are, I think, about 14 or something judges of the Delhi High Court who would have been junior to him had his case been processed in time. But now he's going to be junior to all those 14 judges, which means that he's likely to lose the opportunity of becoming a Chief Justice. And because his case has been pending for such a long time, he might lose the opportunity of becoming a judge of the Supreme Court. So these are, the problems that arise. Now, some of these problems may have existed, but to a very minor degree. And like I said, they were sorted out over a cup of tea. But that's not happening now. That's why there's this problem. You can't have the judiciary and the executive on a collision course. It can't function. How can it function? Yeah.
Thank you, Madan, for that. I mean, speaking from the heart, actually. I mean, very few judges do that. But thank you very much. Now, I think we just have time for just two questions. I mean, I'm sorry that the time is very limited. So, yeah. Okay, go ahead. Go ahead.
Good evening, sir.
Just identify yourself.
Right. Good evening, sir. I'm Abiha Zaidi. I'm a practicing lawyer. I practice here in the Delhi High Court. I mean, I understand the Collegium bit is a little more interesting, but I'm sorry, one of the questions will be on the boring topics, which is pendency. An issue that I face in a personal matter that I'm doing for a motor accident vehicle victim is that we filed it in 2019. That lady met with an accident in Sikkim, and she lost 90% of her ability. So she's a paraplegic now. And the procedure is simple. You all just have to file that claim, a very one-pager application, and it's supposed to be processed ideally within a year or two. The issue that we've been facing because of COVID happened, the lockdowns, and because the owner and the driver were in Sikkim and we filed this in Gurgaon, is that for 3 years this file didn't move. And now finally when it came for evidence last week, the judge came for an hour and then he just went away because he was sick or whatever, fairly so. And then the order records that the plaintiff witness was not present when she was herself in a wheelchair in court with much difficulty. She'd arrived there. Now my question on that personal instance is this. While there are institutional issues with lots of things happening, there are a lot of conduct issues also which lead to, because I don't have an answer to her sons because they ask me why is this not happening, and I as a lawyer I'm like yahan to aise hi hota hai. But it's not a fair answer I can give to the sons whose mother has lost 90% ability. So what do I do? Go to High Court, file a mandamus, and prejudice the judge, or just
you see,
wait?
like I told you, this is a matter of process re-engineering. I'll give you an example. When I was in Delhi High Court, there was a 7-year-old girl who had been raped. Her father was a daily wager. She came to the court 7 times, for recording her statement under Section 164 of the CRPC. Either the judge was on leave, or the judge was busy somewhere else, or something or the other happened, and her statement could not be recorded on 7 different occasions. Now, look at it from the point of this girl. She's a 7-year-old girl who's been raped, okay, and she's coming to the court. So she has to relive whatever happened. Look at it from the point of view of her father. He's a daily wager. He comes to the court, so he loses his wages for that day. An NGO sent me an email saying that, listen, this is what has happened. Can you please ensure that her statement is recorded tomorrow? I took a printout of that email and I gave it to my Chief Justice. And I told him, I said, this is what has happened. Can something be done about it? So he sent it to the bench that was dealing with criminal cases and said that, look into it. And the bench took up the matter that day in the morning. First thing, they gave a direction that her statement be recorded. That case was over. What I'm trying to tell you is that these are areas where we need the processes to be changed. Why did this girl have to come 7 times to court? Why did your client have to come to court in a wheelchair and then be told that, sorry, nothing can be done about it? Don't we have any alternatives? And if we do have alternatives, where are they? And if we don't have alternatives, why don't we have alternatives? So these are, systemic issues which I think somebody has to give it a thought. Okay, it can't change overnight, but you have to make a beginning someday. Okay, so really I don't have any answer to your question. Yeah.
Suhas, may I just, Suhas, I'm here. May I just come in this thing for a second?
Yeah.
If I may address Justice Lokur. When the Motor Accident Claims Tribunals were set up, I happened to be Transport Commissioner of Delhi in 1986. Justice P.N. Bhagwati was the Chief Justice. I approached him. I said, I've got 6 MACTs, cases aren't moving. How do we handle this? He was so kind. He said, set up in Patiala courts. We set up the Lok Adalats for the first time, and the insurance agents, everybody came, and within a Saturday and Sunday, I don't know how many hundreds of cases were disposed of. I entirely agree with what you say, Justice Lokur, is that these kind of cases need to be brought up before these accident claim tribunals and make them work. These are the kind of thing we need to do.
Yeah, okay, the last one now. This doesn't need a comment, I think. Yeah, come to the mic. Come quick. Just identify yourself.
Greetings, sir. I belong from Hindu College, Delhi University. So my question is...
your name?
Yeah, my name is Aditya Gill. Sir, my question is that while you were talking about the judicial education, so how do you see the All India Judicial Services, like as a problem or a panacea for the judicial system?
Well, the contents of the All India Judicial Service, the scheme is not available in the public domain. So there's nothing I can say about it. I don't know what the scheme is. I don't think anybody knows what the scheme is.
So we'll have to close now. Thank you very much, and thank you, Madan, for this.
Suhas, can I ask a question?
No, I'm sorry. We have to close. No, we have to close at 6. I'm sorry. Yeah. So thank you very much, and I think Madan needs a big hand.
Thank you.
Thank you. So I just remind